Good day, everybody. This is Mike Berger again with NC Planning. Today's Daily Counsel topic: contracts are made to be broken. Let me preface this with I'm not encouraging anyone to break any contracts, but questions come up from time to time with clients, with colleagues about contractual reviews, commercial contract context. What are our rights? What are our obligations? What are our liabilities? What is breaking the contract look like? A breach, a default, all these types of things. And oftentimes we are looking at it through the lens of this is what should happen under the terms of the contract, right? This is how it should perform, how it should operate. But sometimes, for one reason or another, you have to go through the hypothetical and model out what it would look like to break or breach a contract. And this got me to thinking, really, when you boil it down, contracts are there. They are built to be broken. And what I mean by that is not to say that we shouldn't pay attention to the contract or we should intentionally look to break a contract. But there are times where, for one reason or another, a party is going to look to exit an agreement. And when I say that contracts are built to be broken or they're made to be broken, what I really mean by that is that there are provisions throughout contracts quite often that map out how an exit is supposed to take place. And I think the way that I like to walk through this with a client or with a colleague is to really get a little bit away from the legalese and go back to some of the very basic fundamental journalism questions we all probably learned in grade school. I think I learned it when I was reporting for my elementary school newspaper. And that's the who, what, when, where, why, and how. Right. So if you apply those questions to a thought process on contract and exit and termination provisions and things like that, you can walk through it and get a pretty good feel. So when we're taking a look at a contract for a client, for a colleague, whatnot, and trying to understand rights and obligations, those are some of the questions we're going to ask and we're going to explore. Who, right? Who are the parties? Who is the contract between? Who has exchanged promises, consideration, or money? And who has then responsibilities rolling forward? What type of contract is it? What are those responsibilities? What do those look like? What does termination look like? What does continuing on with the contract look like? Those types of, what questions I think can help to get you in the mindset to illuminate a lot of provisions that are going to be helpful. When, right? The next question on the list. And that's really one of timing. Some contracts have provisions that say that they're, locked in for a period of time and then they can be exited for cause, without cause, upon election, depending on what industry you're dealing with, whether it's finance, whether it is a vendor agreement, whether it is a customer agreement. Your timing is going to be different, but timing does often play a role in the question of can we terminate, can we exit this agreement? So when is important to understand. And I think when also that question helps to bring into focus what type of timing you have to give to any type of notice. And we'll talk about that a little bit later, but is it a 30-day notice? Is it a 60-day notice? Is it a 1-year notice? When is the timing element right for giving a notice or whatever it might be to exit a contract? Where? Oftentimes, when we're talking about contracts, parties are sitting in different places, but one of the items that comes up quite frequently in reviewing contracts and advising on contracts is where is this contract based, or what jurisdiction, what applicable state is the law that applies for interpreting the terms of this contract. And that can have a great bearing on your exit provisions, on how you terminate, how you exit successfully, and what types of remedies may be available to the other party, what type of responsibilities you may have upon exit or upon breaking that contract. Why? Why are we exiting the contract? And to some degree, you need to understand the business reason behind it, right? That's important because that's going to allow you to measure the risk versus the reward, right? Understand the exit strategy, what the concerns are, what the benefit, what the why is. But also, when we look at why and trying to understand why you exit a contract, it can have legal meaning. One of the most common is whether you are exiting for cause or without cause. That could be an employment relationship. That could be, like I said, a vendor agreement. Is there something that has caused a breach from the other side, you to want to exit? Or is this just, it's not working out, it's not a good fit, it's not a good contractual relationship, and the why is we just want to exit? So why is important for a couple different reasons. Finally, how? How are we going to exit? A lot of contracts have certain provisions in them that allow for the how, certain notices that can be given, 30-day notice, 60-day notice, or whatnot, and how you deliver that notice, whether it's via mail, email, whether it's an oral notice, you can just give it verbally, whether it needs to be writing and signed and notarized, all types of different ways that you can go about with the how to terminate an agreement or to exit an agreement. So that's it for today. A few thoughts, a way to look at contracts that may be built to be broken, right? And that it's okay to think through those strategies, those questions with your advisor, with your counselor, to make sure that you're kind of checking off the list and understanding the who, the what, the where, the when, the why, and the how of exiting a contract. We appreciate you tuning in. If you're joining us on YouTube, please think about giving us a like and a subscribe, as it helps out the channel a ton. I hope you're doing well. Stay safe, and we'll talk with you again soon.